Hi guys, this video is for running through an MBE bar exam question. And generally, I see that there are three methods that you can practice going through the MBE questions. If you have not had a strategy for running through MBE questions, or if you are new to it, I recommend that you watch the three different methods, try them out, see what resonates best with you, and stick to that method, because the more you practice, the easier it gets. And it will also allow you to become more effective at answering these MBE questions. Today, I will be running through a civil procedure MBE practice question. For the three methods, the first, probably the most popular method, is where you look at the call of the question, then you go through the fact pattern, then you reread the call of the question and run through the answer choices. Generally, I recommend that as you're running through the fact pattern, you would want to start racking the fact pattern by identifying the issue, identifying what rules are associated with that issue, and then thinking through the application of the law so that you can come to a fairly solid answer before getting to the answer choices. Even if you don't come to a solid answer, you would want to get around the general area of what you think the answer should be before looking at the answer choices for this first method. For the second method, you would have the second most popular method is to go through the fact pattern, then go to the question, then go through the answer choices. And again, with this, you are using the same strategy. You are racking the question as soon as you start reading the fact pattern, so that by the time you get to the answer choices, you should have a very good general idea of what that answer should be if you have studied your substantive law well. The last method is what I would consider a little bit more advanced. If you can do it well, it really can help you save some time, as well as possibly allow you to be able to even skip the fact pattern without having to worry about trying to run through the analysis, because you can get fairly good at being able to eliminate answer choices. But as I said, if you are new to MBE questions, or if you have struggled with MBE questions, that may not be the best method, at least not the best method for you to go through to start with. Let me share the question we'll be running through today. This is a civil procedure question. We'll run through the call of the question first, then the fact pattern, then the call of the question, and look at the answer choices. And as you're going through the call of the question and the fact pattern, what you would want to do is to, what I call, rack the prompt, so you can get a really good sense of what the answer should be before picking one of the answer choices. So the call of the question is, how is the federal court likely to proceed? When you look at this, it's a pretty safe bet that this is a civil procedure question. You can change your mind if you discover that they played a trick on you and shift gear as needed, but at this point I would be thinking it's a civil procedure question. We don't know what they need to decide on, how they are likely to proceed, so we're still at a loss for that. Since it's such a short fact pattern, I would just go right to the fact pattern and not have to worry about looking at a sentence before or a sentence or two before the call of the question to get a better sense of what you will be looking at. The fact pattern says a woman sued her former employer in state court. Since we are in the frame mind of knowing or thinking that it's a civil procedure question, the words that you want to be highlighting would be things such as what I just underlined, which is the parties involved and then what courts are involved. So it's important to look and see that it says the woman sued her former employer in state court. The woman is the plaintiff, the former employer is the defendant, and the state court is the court they're in, asserting age and sex discrimination claims under both state and federal law. So she's asserting both state and federal law. The woman's attorney had recently been embarrassed in court by the judge to whom the case was assigned. Wishing to avoid difficulties with the judge, the woman's attorney promptly removed, that's a civil procedure term, removal. At this point, go ahead and finish the sentence, but that should trigger lots of bells to go off in your mind, where it says it's giving you a buzzword, a key subtopic for civil procedure. Promptly removed the case to federal court. So this should bring you back to thinking they were in state court. Now they are wanting to remove it to the federal court on the basis of federal question jurisdiction. At this point, I would stop and I would think we have a removal issue that they're testing you on. So what you will want to do is think about what are the rules associated with removal. Removal, the general rules that they usually test you on would be only a defendant may remove. And if you look at what this is saying, there should be red flags if you know that removal requires a defendant to be able to remove. Plaintiffs cannot remove. Immediately when it says the woman's attorney, she's not allowed. My inclination is they cannot do this. Fact pattern then goes on to say the employer's attorney has timely moved to remand. That means that the defendant's attorney moved for it to be remanded back to the state court. Okay. The call of the question again is, how is the federal court likely to proceed? And the answer choice is, at this point, your answer should be that the federal court should remand the case to the state court because it was improperly removed to the federal court. A, the answer choice is remand the entire case. That looks pretty good to me. B, remand the state claims but keep the federal claims. They can remand the state claims, but the federal claims cannot remain in federal court because it was improperly removed to federal court. So I can cross that out. Answer choice C, retain the case to avoid the risk of bias and impropriety in having it proceed before a judge who has shown clear hostility toward the woman's attorney. Retaining the case can only be allowed by the federal court if they have the authority to hear it because it was properly removed to their court. It's not properly removed because here the defendant was not the one that removed the case. It was the woman that removed the case. Therefore, they cannot retain the case. If the problem is impropriety of the judge, the attorney can always move to have the judge remove from state court and have it be heard by a different judge in state court. So this is not a good answer choice either. Answer choice D, retain the case because it was timely removed. We don't really care about the timely remove part, but for those of you who are wondering, you need to do it within 30 days. But they didn't give us a time in this fact pattern. That's another hint that this is probably what they're not. This is probably not what they're testing you on. So it is a hint that that's probably not the best answer choice. It was not properly removed, not because of timing, but because it was removed by the plaintiff, which is a no-no. And the woman alleged federal claims. She did allege federal claims, so yes, that is all right, but it's not the issue here. The improper removal issue is that it was removed by a plaintiff, not a defendant, and only a defendant may remove to federal court. That is also a wrong answer choice. The answer should be A. Now we will run through the question from top to bottom, starting at the fact pattern. The fact pattern begins, a woman sues her former employer in state court. Things to highlight would be the parties involved. A woman sued her former employer in state court, asserting age and sex discrimination claims under both state and federal law. We're starting to see that this is maybe a CIPRO question. The woman's attorney had recently been embarrassed in court by the judge to whom the case was assigned. Wishing to avoid difficulties with the judge, the woman's attorney promptly removed the case. Now we know for sure, promptly remove. It's confirmed that this is a civil procedure question in the testing on removal. So at this point, you can continue on to finish up the rest of that sentence, but bell should be ringing in your head, thinking that this is what they're testing you on, and you can start unracking your fact pattern. The woman's attorney promptly removed the case to federal court on the basis of federal question jurisdiction. At this point, you should be thinking they're testing you on removal and all aspects of removal as the subject matter itself. Generally, only a defendant may remove, and not applicable here, but all defendants have to consent. And removal, in order for you to remove, you need to have the federal court needs to have subject matter jurisdiction. In this particular case, though, if you have caught that the woman is the plaintiff and the woman's attorney is the one that has asked for the removal, then that's an improper removal because she's a plaintiff. He's representing the plaintiff. He cannot remove the case as the plaintiff. The call of the question is, how is the federal court likely to proceed? Your answer should be that the federal court should remand the case. And sorry, I forgot to read that last sentence there, but the last sentence is that the employer's attorney has timely moved to remand. The employer's attorney is the defendant, and they are challenging the removal. They have proper grounds to challenge the removal because the removal was improperly done, since they are the plaintiffs and they cannot remove the case to federal court if they are the plaintiff party. So your answer should be the federal court should remand the case to state court because it was properly removed, since the removal party is the plaintiff. Right? Answer choice A, remand the entire case. That sounds good, because if we were thinking that the removal was improper because of it being removed by the plaintiff. Answer choice B, remand the state claims but keep the federal claims. It's okay for them to remand state claim, but they cannot keep the federal claim because the federal claim is improperly in the federal court, since it was improperly removed, since it was removed by the plaintiff. Answer choice C, retain the case to avoid the risk of bias and impropriety in having it proceed before a judge who has shown clear hostility toward the woman's attorney. They can't retain the case just to prevent bias in the lower court. If the case is improper in their jurisdiction, they cannot retain the case. And in this situation, the case was improperly removed to their court because it was removed by the plaintiff party. They have to remand. If there is a risk of bias in the state court, the plaintiffs can always have that judge be challenged and removed from the case, so that they just move the case in state court for a different state judge to listen to the case. So this is not a good reason for you to keep the case in federal court. So C is also not a good answer choice. D, retain the case because it was timely removed and the woman alleges federal claims. Federal claims, that's true. There was a federal claim that she filed, we don't know if it was or was not timely removed. So that's a hint that that's not a good answer choice, since it's not in the fact pattern. You don't need to be inferring things that are not in the fact pattern. That's a huge hint that this is probably not a good answer choice, especially since you do have answer choice A available that matches up with your thinking if you had properly studied your substantive law with respect to the removal issue. The issue is that they cannot retain the case because it was improperly removed, since it was removed by the plaintiff party. So the answer choice should be A, remand the entire case. Now we'll run through this question by looking at the call of the question, then the answer choices, then go back to the fact pattern. The call of the question is, how is the federal court likely to proceed? This is a very good indication that it's a civil procedure question. It could be that they are testing you in another area of law that's more substantive rather than procedural. However, just think that it's a civil procedure question and shift gear if you end up seeing other hints that they're testing you in another subject area. Going through the answer choices, answer choice A says remand the entire case. So we're looking at remand as a subtopic that they could possibly be testing you on. That is a confirmation that you are looking at civil procedure as a subject matter. Then the answer choice B says, again, remand. That's another hint that it is a civil procedure question. Remand the state claims, but keep the federal claims. So we've got state claims and federal claims. Then answer choice C says, retain the case to avoid the risk of bias and impropriety and having it proceed before a judge who has shown clear hostility toward the woman's attorney. It doesn't sound like a very good answer choice to me, because you don't allow a court to retain a case to prevent bias. There isn't a rule that is associated with that. Retaining a case, a court can retain a case only if they have jurisdiction to listen to it. So that to me would be a sad face answer choice. Since there are two answer choices that we did not eliminate, I would be very unlikely to pick this as the correct answer choice. Then answer choice D, retain the case because it was timely removed and the woman alleges federal claims. So now we are seeing that we are getting a better picture of the testing on removal and remanding. The answer choice in D says retain the case because it was timely removed and the woman alleges federal claims. This seems to be another viable answer choice because removal requires you to have it done within a certain amount of time. Timing is important and claims are important. At this point, you may want to start thinking removal as what are some things about removal that you learn from your bar prep? And that would be removal with respect to this. Not generally, you have 30 days to properly file a case to be removed to federal court. The woman alleges federal claims, and yes, you need to have a federal claim. Basically, you need to have subject matter jurisdiction. The federal court would need to have subject matter jurisdiction in order for them to have the ability to listen to a case that's properly removed. And subject matter jurisdiction would be first, either you have a diversity or a federal question. Or a federal question. So that really helps with thinking that these would be things that you will be looking for. Other things that are not being triggered by this answer choice, but one of the important rules in removal that they test on frequently as you study, if you study well for this exam, is you know that only a defendant may remove the case. So keep that in mind as well in the back of your head in case that's triggered by the fact pattern. Only a defendant may remove, and all defendants have to consent. So those are things that you should have in the back of your mind as you're going through the fact pattern. When you go to the fact pattern, it starts out, a woman sued her former employer in state court asserting age and sex discrimination claims under both state and federal court. In that sentence, I would make a note of the woman being the plaintiff, because if you know the rule that only defendants can remove, it's going to be important. The woman sued her former employer. The former employer is the defendant in state court, and they're asserting age and sex discrimination under both state and federal law. So they are making claims for federal law, which is what we saw in the answer choice in D. So that is, at this point, as far as we can see, that she has filed a federal claim. D is still a viable answer choice. The woman's attorney had recently been embarrassed in court by the judge to whom the case was assigned. Wishing to avoid difficulties with the judge, the woman's attorney promptly removed, and here the removal issue comes up. The woman's attorney properly removed or promptly removed. The woman's attorney is the plaintiff. So if you know that only defendants can remove at this point, you should be thinking that this is an improper move by the plaintiff's attorney, but go ahead and finish the sentence. The woman's attorney promptly removed the case to federal court on the basis of federal question jurisdiction. It's okay for federal question jurisdiction, but for the removal part, since she is the plaintiff, her attorney cannot remove the case. Based on all the answer choices, then, the retain the case C and D you can cross out, because this is an improperly removed case, which means that the federal court cannot retain and listen to the case because they don't have jurisdiction to do so. Then the last sentence of the fact pattern says the employer's attorney has timely moved to remand. So with respect to remand in A and B, remand the entire case, that sounds pretty good. B says remand the state claims but keep the federal claims. The difference between A and B is A have you remove or remand the entire case versus B says you can truncate, put the state claim to state court and then keep the federal claims. Well, we already decided that the federal claim or any claims at all cannot stay in the federal court because it was improperly removed, since the plaintiff was the one that removed the case. So A is the best answer choice.